How do you terminate an easement? Have you ever wondered how to end an easement? It can be a tricky process, but understanding the steps can help you avoid common pitfalls. Let's break down the ways to terminate an easement and what you need to know. First up is expiration. If an easement was created with a specific time limit or condition, it automatically ends when that time runs out or the condition occurs. For example, if an easement was granted until a certain event happens, once that event takes place, the easement is no longer valid. Next is releases. The owner of the easement can formally releases it by signing a written agreement. This document must meet legal requirements, especially if the easement lasts more than 1 year. A common mistake is not properly documenting this releases, which can leave the easement in place. Abandonment is another method. This requires clear evidence that the easement holder intends to stop using it and has taken action to show this intent. Simply not using the easement is not enough. For instance, blocking access can indicate abandonment, but misunderstandings about this can lead to disputes if the easement holder decides to use it again later. Then we have merger. If the owner of the dominant estate and the servient estate become the same person, the easement typically ends. This is because you cannot have an easement over your own property. A common error here is failing to record this change in ownership, which can create confusion about whether the easement still exists. Destruction of the purpose is another way to terminate an easement. If the reason for the easement no longer exists, like if a shared wall is demolished, the easement may end. Misunderstanding what qualifies as destruction of purpose can lead to legal challenges. There are also other legal methods to consider. Condemnation, where the government takes the property, and adverse possession, where the servient owner takes over the easement area through continuous use, are examples. Expiration of necessity can also apply if the easement was created out of necessity and that necessity ends. To avoid common legal mistakes, always have termination agreements in writing and properly recorded. Do not assume that non-use means abandonment. It is important to document clear intent and actions. Consulting a real estate attorney before trying to terminate an easement is wise to ensure compliance with local laws. Keep clear records of any changes in property ownership that might affect easements. Lastly, understand the specific terms and conditions under which the easement was created to see if automatic termination applies. By following these steps, property owners can effectively manage and terminate easements while minimizing disputes and legal risks.